On record in State versus Davis, C377407. My understanding is we have one thing we need to address outside the presence before we bring the jury back in.
Yes, I guess two things, Your Honor. First is we'll be admitting some jail calls. We've edited those down to not include the lead-in and just the relevant portions as opposed to Mr. Samp, who are those redactions. The issue that Mr. Samp raised to me was regarding, we're playing about, I think, less than 10 minutes of YouTube video. But Mr. Sant has an issue with the...
So the jail call issue is done?
The jail call issue is done.
You're just putting that on record, that there's no objection to the foundation for that, and you're not doing it through the custodian of records?
Yes, we had agreed ahead of time.
Got it. So moving on to the issue with the YouTube videos.
Yes, Your Honor. My understanding is Mr. Sant has an objection as to the foundation for the YouTube videos.
That's correct, John. My understanding is that they're going to produce an individual that works for the Clark County District Attorney's Office will come here and basically just say that he found the videos on YouTube. I don't think there's going to be, I don't think there's going to be foundation laid properly in terms of when the videos were taken, by who, along those lines. And so as a result, we would just do a preliminary objection to the foundation. Maybe the state will lay that foundation during the course of the trial.
And what's your proffer as to what you expect the foundation to be? That
our discovery technician went on YouTube and saw the defendant's face. And nothing is off camera. It's the defendant's face, and that he's talking in a very recognizable voice that we have all heard. And I think that's sufficient foundation for that. It speaks for itself, similar to the book situation.
And what's your objection that the video is not what it purports to be, as to foundation, essentially?
I'm sorry, Your Honor.
So, foundation, the essential question is that the item being proposed is what it purports to be. What's your objection on those grounds?
I don't think there's an objection that it is Mr. Davis that's on the video. It's more of when and where the videos were taken. So it's not the same group of characters that was from the testimony of Mr. Dorsey, for instance. It's other people doing those videotapes. So as a result, if there's foundation later on that I'm not, then I think that satisfies that.
I think it satisfies foundation that it is a video of Mr. Davis. It's what you're proposing it be.
Yes.
I think there's probably going to be questions and argument regarding when it was taken, who took it, for what purpose, etc. But as to foundation, I don't think that's lacking.
Okay. All right. I at least wanted to have that out before the jury came in instead of in the middle.
Okay, sounds good. So that's my preliminary ruling on that. We can raise it in the moment if there's anything more, if there's more doubts that come up, Mr. Sampt. Okay.
Yes, Your Honor.
All right. Anything else? Anything from your side?
Do you recognize what State's Proposed 165 is?
I do.
What is State's Proposed 165?
Is a CD of YouTube exhibits.
And does this CD contain the actual videos that you compilated and then clipped?
Yes, there should be 3 videos.
Your Honor, at this point, I'm going to move State's Exhibit 165 into evidence.
Any further objection, Mr. Sampt?
No, Your Honor.
All right. Over objection, they will be admitted.
At this time, we're going to publish State's Exhibit 165.
You may.
Before we get into this, again, these are very small snippets of much larger and longer videos.
Yes, very much longer interviews.
In order?
Let's do the book first.
You and Orlando and everyone else meets up, but you guys don't have any guns.
Who said that?
Well, it was in the book. Until Von Zip came in the picture.
All right, let's. I don't want to talk about that.
Okay,
Let's
but it is in the book.
Okay, yeah. Let them read about it.
Okay, and I guess Foxy Brown was with Zip.
Let them read about it.
Okay. Well, according to the book, which there's going to be a link in the video that you could actually order from.
That's right. Matter of fact, let me see my book.
You want to go ahead and show the book?
Yeah, let's show the book. Yeah, this is my book here. I would like you guys to buy it and get the real truth instead of from a cop or some fucking industry people, some bullshit. You getting it from the real motherfucker. So go get the book, and you can get the real truth about this whole situation. Thank you.
Okay. Well, I'm going to go ahead and read from the book passage.
Okay.
on getting a gun for the Tupac hit. While we were waiting for the valet to bring out our cars, Zip seized the opportunity and called me over to his Benz. Zip was a big-time New York player, pimp, and hustler who used to come out to California and handle his business and kick it with us sometimes. As I walked up to the driver's side, I noticed the rapper Foxy Brown was in the car with Zip. So he instructed her to step out of the car and motioned for me to jump in. Zip had a hidden compartment, and he opened up, reached in, and pulled back a 40 Glock.
Like I say,
He turned to me and said, "It's time to get the money."
like I say, get your $20 and read about that part.
I'm going to play the second file.
You had cancer at one point?
Yeah.
You beat it.
I beat it, yeah.
Right? It was a colon cancer?
I told you I beat 3 of the baddest entities in the world. United States government, fucking cancer, and the streets.
And then one last time.
Let me tell you something, my brother. Tupac and them jumped on him. He was by himself. He didn't my nephew never jumped on no fucking Tupac. Come on, man. Tupac was wrong with 2 left fucking shoes, nigga. I mean, don't you think he was wrong? Honestly.
I mean, yeah, I think he could have, reacted in a better way.
You listen, homie. You don't think that man is wrong?
He could have reacted in a better way, I guess. I mean,
I'm talking Vlad is his fucking biggest fan. He admitted that man is wrong, man.
Yeah, man. He
Come
was
on,
wrong, man, but that was only done out of loyalty, man.
Okay, thank you. I appreciate that. He never jumped. My nephew didn't jump on him. He jumped on my nephew, a kid, man. My nephew was a fucking kid. Them was grown-ass men, dude. You know what I'm saying? He was a fucking kid, dude. That's why he had on that jersey. He's a fucking kid, dude. You know what I'm saying? They was wrong. My nephew never jumped on him. They jumped on my nephew. My nephew didn't throw a punch, man. Shit was wrong, dude.
And then, as part of your duties working for the Clark County District Attorney's Office, did you also receive video from the courtroom proceedings in this case?
I did.
And did you receive the one view from a television network and another view that you synced up?
Yes, I did.
And how do you do that?
I used Adobe Premiere Pro. Took both videos, entered them into the same timeline, and then set them side by side and synced them up so that they played. It's the same video. It's the same video from different angles.
And I'm going to approach you State's proposed Exhibit 166. Did you actually put that compilation on a video? And then, did you put that video on a CD?
I did.
And is this the CD that you put it on?
Yes, it is.
All right. Your Honor, this time State's going to move 166 into evidence.
Any objection?
No objection, Your Honor.
So admitted.
This time State's going to publish 166.
I have everyone back here at 3:40. Please rise for the jury.
At that time when Reggie Wright Jr. is sitting in front of the witness stand, that Mr. Davis is mouthing words at Reggie Wright Jr.
Yes.
As part of your duties with the Clark County District Attorney's Office, did you also have access to calls that Mr. Davis made since September of 2023?
I do. I did.
And did I ask you to review some of those calls?
You did.
And did I ask you to clip some portions of those calls for the purpose of a presentation here today?
Yes.
I'm going to show you what's been previously marked as State's Exhibit 164. Is this CD the CD that you prepared containing those clips of calls?
Yes, it is.
All right, at this time, State's going to move 164 into evidence.
Any objection?
No objection, Your Honor.
So admitted.
This time, State's going to publish State's Exhibit 164. We'll go in chronological order. So can we play the 10, 12, 23?
Everything gonna play out for me, though. Everything gonna be cool. They just trying to use the words I said against me, but they can't do that shit. So,
well, shit, they trying it.
well. I didn't break the thing that fucking Greg hated the thing. Shit.
I just wish you would have never did, dog. You know, just let that. You would probably have been in jail. No, I forgot. I just wish you would have never talked to that man. You know.
Yeah, you're right. I know. I should have just went on and did that little.
Stop doing all them interviews and that. Just never did none of that shit. I should have said whatever happened. You know.
Yeah, you're right.
Everybody, that shit all over. All you see on Instagram, that all that shit. I'm like, damn, this shit is viral.
Yeah.
Now, Mr. Starr, you've listened to this calls maybe one or two or more times. Is that fair?
That's fair.
In terms of editing it, is it fair to say that while some of the audio is a little bit garbled, upon hearing it a number of times, you're able to discern some of the words that are being stated?
Yes.
And is it fair to say that Mr. Davis says they're trying to use my words against me?
Yes.
And that he says, I didn't break the thing, Greg Kading broke the thing?
Yes.
Okay. Now can we play the next call at 10:21:23?
Yeah, they ain't got shit though. They trying to use my statements against me. You gonna lose, dude. I was paid to say that, stupid ass dude. Yeah.
Okay.
I was paid to say that, stupid motherfucker. You can't use my shit against me, you stupid.
And then what's this book they say you wrote?
Yeah, I did. After that dude did that, I didn't breach that contract. He did.
Okay.
He made money off Carrot Top. You know what I'm
Uh-huh.
Oh, bitch. He had my life fucked up. I clawed it up under a rock for 6 years. And I just got tired of it. You know what I'm saying? Shit. Let them know the motherfucking truth. Bitch, you ain't just got me, motherfucker. You niggas around me got you for me.
Mm-hmm.
That Dirt Rock, all them son of a bitches. You know?
Wow.
Yeah. Even my boy Jerome down the street from you. And Lil Rizal, all them motherfuckers. I'm like, damn. You know, all that shit. You know?
And similarly, have you listened to this call more than one time?
I have.
And is it fair to say that Mr. Davis says they're trying to use my words against me?
Yes.
And in fairness to Mr. Davis, he does say, I was paid to say those words.
Yes.
And then he says, when he's asked about what's that book you wrote, he says, yeah, I wrote that book.
Yes.
And then later on he says I'm going to quote, let the motherfuckers know the truth.
Yes.
Okay. And then he later on says, regarding Greg Kading, you didn't get me, and then says some people who actually did get him.
Yes.
Okay. Can we play the 11:9:23?
Deadline. So I'm gonna call Edie. I'm gonna call him today, and then when you call me later on tonight or tomorrow, I know.
Okay.
Okay.
Love, my bro.
All right, I'm looking out for you, big dog. All right.
But once I get home, man, we rich.
Oh, of course. Of course.
All right, I got to tell Keith, dude, you know what I'm saying? Don't let them throw that motherfucking shit up in your face. We be mad the motherfucking 10 years later. Next series still going. You know what I'm saying?
Yeah.
Yeah. Make us want to, you know, I got to tell that nigga, I got blood on my money. All right, what's up, bro? Okay.
All right, big dog. All right. Talk to you later. Peace.
Similarly, had you listened to this call a number of times?
Yes.
Is it fair to say that Mr. Davis says, I have blood on my money?
Correct. Yes.
Court's indulgence. State will pass the witness.
All right, Mr. Stamp, cross-examination.
No cross-examination.
Ladies and gentlemen, any of the jury, any questions for this witness? Seeing none, thank you, Mr. Starr. You're free to go. State who's your next witness.
Judge, reserving the right to confirm with the clerk that everything that we've offered has been admitted. At this point, the state will rest.
Defense. We're moving into your case in chief.
Yeah, maybe a question.
You may. Okay. Mr. Stamp, anything you wanted to put on the record?
Yes, Your Honor. With regards to the defense's case in chief, we have witnesses lined up. We cannot make it here today. There will be officers from the Metropolitan Police Department that will testify on behalf of the defense. Because of the fact of their scheduling, we're unable to get it today. We would ask the court to allow us to start our case in chief tomorrow with a detective and 2 police officers tomorrow.
Okay, ladies and gentlemen, we're way ahead of schedule ultimately. The defense at this point is moving into their case in chief. It doesn't have their witnesses available until tomorrow. So we are going to recess for today and have you guys back here at noon tomorrow. During this recess, you are admonished not to talk or converse amongst yourselves or with anyone else on any subject connected to the trial, or read, watch, or listen to any report or commentary on the trial of any person connected with this case by any medium of information, including without limitation, newspaper, television, the internet, and radio, or form or express any opinion on any subject connected with the trial until the case is submitted to you. Sorry, we'll see you guys tomorrow. Please rise for the jury. For the record, the jury has exited the room. Everyone can be seated. Mr. Davis remains standing. I have to admonish you on your right to testify at this time, just so you can make that decision overnight with your attorney, okay? Mr. Davis, under the Constitution of the United States and under the Constitution of the Constitution of the State of Nevada, you cannot be forced to testify in this case. Do you understand that?
Yes, ma'am.
You may, at your own request, give up this right and take the witness stand and testify. If you do, you will be subject to cross-examination by the Deputy District Attorney, and anything that you may say, be it on direct or cross-examination, will be the subject of fair comment when the Deputy District Attorney speaks to the jury in their final argument. Do you understand that?
Yes, ma'am.
If you choose not to testify, the court will not permit the Deputy District Attorneys to make any comments to the jury because you have not testified. Do you understand that?
Yes, ma'am.
If you choose not to testify, the court will instruct the jury, if your attorney wants me to, as follows. The law does not compel a defendant in a criminal case to take the stand and testify, and no presumption may be raised and no inference of any kind may be drawn from the failure of a defendant to testify. Do you have any questions? Do you understand that?
Yes, ma'am.
Do you have any questions in general about these rights?
No, I'm good.
You understood? Okay. You're further advised that if you have a felony conviction and more than 10 years has not elapsed from the date you were convicted or discharged from prison, parole, or probation, whichever is later, and and you elect to take the stand and testify, the DA will be able to ask you in the presence of the jury the following. 1, have you been convicted of the felony? 2, what was the felony? And 3, when did it happen? But the DA cannot get into details about that. Do you understand that?
Yes, ma'am.
Okay. I'll leave it to you and your attorney's consultations as to what your decision is, but I just wanted to give you those rights at this time.
Okay.
Okay.
Judge, and just for the record, because Mr. Stamp may not be aware of this, we checked the 2015 conviction. It ran on August 11th of 2026. So the only conviction that he would be facing cross-examination for is his conviction a couple of years ago for battery by a prisoner.
Okay. All right. Yes, sir?
Is that why they sent them to attack me?
I understand that's your position, that happened, but ultimately, I don't know anything about that case. I've never looked at it, okay?
Okay, ma'am.
All right. Okay, you guys can be seated. Anything else we need to address outside the presence? Okay.
So we'll just need to go with jury instructions.
Yes. So I've been working on jury instructions. Ms. Panda asked that we include a Carter instruction just in case.
A what instruction?
A Carter instruction.
Carter, okay.
And then Ms. Panda also asked about a voluntariness instruction. We have some thoughts on that. So
A voluntariness or a voluntary manslaughter?
The voluntariness of the statement.
I understood. Okay.
And so we have some thoughts on that. So we're preparing something that we think conforms to this court's ruling, and then we will probably have a corpus delicti instruction as well.
When did you want to settle?
I'll get this to Ms. Pan. I assume Ms. Would you like me to send to Ms. Panduct? Okay, I'll get it to Ms. Panduct this evening, and then I'll if we can probably do it Friday morning or Thursday, probably Friday morning probably best, or Friday sometime during the day. Settle those during that time, so Ms. Panduct has some time to review with Mr. Saft what the instructions are.
Okay. All right. So we'll plan on settling those probably Friday morning. Sometime. Okay. Sounds good.
The only question I would have is, the two rebuttal witnesses I have to, one, I know that they're calling. Should I have them here at 2 tomorrow? Because I don't imagine Mr. Stanton's going to be very long, or should I have them here at 9 o'clock on Friday?
No, don't do that. If we could just have them here at 2 o'clock, that should work.
Okay.
Okay,
All right.
sounds
So
good.
I'm going to try
So
and get them here for 2.
have everybody here at 2. Maybe we may have the submission of the case at least wrapped up by the end of the day tomorrow.
Yes.
Okay. All right. Thank you guys. We'll be in recess.